Hello, everybody. Welcome along to our virtual event, which is called The Impact of COVID-19 on SEN Provision. Hopefully you can see me in a video box somewhere on your screen. Later on in the presentation, I'm going to hand over to my colleague, James, who unfortunately, despite the wonders of modern technology, hasn't been able to get his camera to work. So it's just me on video today, but James will be speaking to you later from a blank screen. So firstly, just a big warm welcome to all of you for joining us today. We've got lots of you on the call and some more might join as we go along as well. So it's fantastic to be able to speak to so many of you through these new ways of working now that we are all working from home. So my name is Caroline Barrett. I'm a senior associate solicitor here at Owen Mitchell, and I specialise in education law, as you might have guessed. And my colleague who will be speaking later on in the presentation is James Beck, and he's based in our Manchester office and also specialises in education. Just see if I can move my screen on. Oh, there we are. Oh, that's us, so that you can see a picture of James, even though you won't be able to see him on the video later. So lots of you, as I said, are on the call with us. Some of you have already sent us through some questions that you wanted us to answer as part of this webinar. So we've done our best to answer as many of those as we can going along. And at the end of the session, we've picked out a few of them and given them specific answers as well. If, whilst we are doing this presentation, you have any other burning questions that you would like to ask us, there should be a Q&A panel, which you can find on your screen. So for me, it's on the right of my screen. It just says Q&A. For some of you, it might be somewhere else. If you open up that box, you can type in a question. It will come through to the panelists here. And at the end of the session, we're trying to leave about 20 minutes at the end to get through as many of those questions as possible and to pick out the main ones that we haven't been able to answer during our session. So what we're going to try and do in the webinar is to go through these slides, try and hopefully explain some of the changes that have happened over the last couple of weeks in terms of the law, and hopefully to leave you a little bit more reassured, because, you know, change is always a little bit unsettling. The new laws that have come in over the last couple of weeks do change the legal framework and change the picture a bit in relation to SEN provision. And so hopefully by the end of this session, you'll feel better informed, but also, we hope, a little bit more reassured about what should still be happening on the ground and how people's needs will be met. Right, see if I can. Here we go. So this is what we're going to try and cover in today's session. So we'll talk about the Coronavirus Act itself and the government guidance that's come out alongside that, and how that might change the current picture on the ground. As well as looking at what might change, we'll also look at what local authorities should still be doing. We'll look at the impact on tribunal appeals, the impact of school closures and how that should be managed at the minute by local authorities and by schools and, of course, by parents. And we'll briefly look at social care, which we're covering briefly because obviously social care should be within children's EHC plan, but deserves a whole nother topic in its own right. So where are we now? Well, we are in a very sort of brand new situation. Things are very quick moving. The Coronavirus Act was sort of rushed through Parliament very quickly. It was emergency legislation. There was very limited debate on it. And it doesn't only affect special educational needs, it impacts all of our lives. The fact that we can't go out of the house anymore, for example. Also things like public health generally, local authority duties in lots of different areas. And so there has been limited scrutiny of the Act itself. Since the Act was passed, further guidance has been issued in a number of areas to try and flesh out the detail of what it all means. And the guidance has come in for a little bit of criticism because it softens the Act in a number of areas There's sometimes a little bit of a disconnect between what the Act says and what the guidance says. But we'll go through that guidance in a bit more detail. And obviously, as we know at the minute, the majority of children are not attending school. That's been in place since the 20th of March, and at the minute there's no end date as to when schools will be reopening. So let's talk about the Coronavirus Act itself. We've got the Coronavirus Act, and then we've got all the guidance that's been issued as well. So on the screen, we've listed the three main pieces of guidance that apply to special educational needs. So there's guidance for schools, childcare providers, colleges and local authorities. There's guidance on vulnerable children and young people, and there's guidance for parents and carers. And this, as I say, kind of fleshes out what the Act says in a bit more detail and gives a bit more guidance about what local authorities should be doing in these brand new times. So specifically in relation to duties that relate to special educational needs, these are the main duties that it has the potential to affect. So what the Coronavirus Act does, in Schedule 17, it lists the way that the Secretary of State might be permitted to alter the duties that apply to children with special educational needs. Now, although this Act is in force, at the minute, none of the duties have changed. So in order for these duties to change, the Secretary of State for Education will need to issue a notice. But these are the things that the Act says that he can change if he wants to do so. So Section 42 of the Children and Families Act, many of you will know, that's the duty that says that local authorities have to make provision as set out in Section F of an EHC plan. And this could now be changed to the local authority only has to take reasonable endeavours to make this provision available. Section 43 of the Children and Families Act, that's currently the duty to admit children to the school that's been named in their EHC plan. So that duty could also be disapplied. Section 44, subsection 1, that's currently the duty to carry out an annual review every 12 months. That could also be disapplied. And Section 19 of the Education Act, that's the duty to ensure that children have access to suitable education, which includes the duty to make provision in pupil referral units or elsewhere for children who are out of school because of illness or otherwise. So those are the main areas. I mean, there's lots of things that are affected by the Coronavirus Act, but those are the main duties that we think will affect children with special educational needs. So how would these changes actually be made? Well, as I said, none of those changes are actually in force yet. At the time that we're speaking to you today, the Secretary of State for Education has not yet issued a notice which says that he is going to make those changes, but we anticipate that at some point he will do. But when that notice comes out, it will have to say exactly which duties are going to be modified or disapplied. The Secretary of State would have to say in that notice why it's an appropriate and proportionate action in all of the circumstances. And it has to relate to the incidence or transmission of coronavirus. So this can't be a kind of carte blanche that carries on forever because local authorities are still short of cash, for example. It has to specifically relate to the incidence or transmission of coronavirus. And these notices can only apply for a period of up to 1 month. So the Secretary of State could issue a further notice after that 1 month period, but each time he issues that notice, he's going to have to justify why it's an appropriate and proportionate action in all the circumstances relating to the incidence or transmission of coronavirus. And I think that's important because in the scope of social care changes, local authorities are given much broader authority to effectively make decisions as they see fit to have these easements on social care duties, and they're given much more discretion to make the call. Whereas here in the realm of SEN, it's the Secretary of State that has to issue that notice, and it's very time limited. And so we hope that these changes would only take effect for a short period of time only. So what might this mean in practice? Well, I think it's really important to say that local authorities would still be required to use their reasonable endeavours to make the provision that is set out in the EHC plan. And so it's not getting them off the hook and not providing what's in the EHC plan. we would expect local authorities to be explaining and justifying if they can't make provision for a certain reason, they should be explaining why they can't. And there are lots of ways that we can be more flexible with local authorities to get at least some of that provision in place. So as I said on the slide, if, for example, there is a staff shortage, SLTs, for example, could SLT provision still be made but at a slightly reduced rate? Can remote therapy be done by video link? Alternatively, could a direct payment be made available and a parent could find their own therapist if the local authorities ones, if there's a shortage of local authority staff for a while? And there might be a delay in getting some of this provision in place, but could it still be done? So reasonable endeavours should be made to get that provision in place. And I think it's worth saying that we don't know how long this situation is going to go on for, but it should be time limited. And once all of this is over and we go back to normal and these notices no longer apply, local authorities will still have this absolute duty to provide what's in Section F of the EHC plan. So it's sort of not in their interest to just not do anything. They need to be using their reasonable endeavours and doing what they can, because otherwise they're going to have a mountain of stuff to catch up on once the coronavirus pandemic is over. So, as I said, local authorities still need to show they are making efforts to make the provision available. For me, the reasonable endeavours duty means that a blanket stoppage of something, for example, if a local authority says we are no longer going to be able to provide OT for the next 3 months, that's the sort of thing that could be susceptible to challenge, because is that reasonable endeavours? The local authority would need to justify that they've used all reasonable endeavours to make provision available for children. And as I've said in the previous slide, there are lots of flexible ways that support could be provided. And so we're definitely not seeing this as an opportunity for support just not to be provided at all. I think it's also important that everyone realises that further regulations might be issued by the Secretary of State, which could also change the timescales for things like issuing EHC needs assessments and EHC plans. So there might be some impact on how EHC plans are issued. But as I said, that being said, we hope that these changes will only take effect for a short period of time. One of the other duties that the Secretary of State has the power to disapply is that duty to admit. So I mentioned it a couple of slides ago. So where a school is named in Section I of an EHC plan, that duty might no longer apply. So what might this mean in practice? Because I know lots of parents are concerned about that. Well, practically speaking, if a school is named in an EHC plan, my initial view, hopefully not a naive one, is that most schools are still likely to admit anyway, because we have to remember that once this pandemic is over, then these duties will revert to being duties. And so if schools say we're not going to admit the child, then as soon as this is over, they're going to have to admit them anyway. So where schools can accept children, my view is that they are likely to still accept them. We obviously recognise that lots of schools might remain closed for a while and we don't know when they're going to reopen. But subject to that, I would hope that it's not going to be as big of an impact as you might first expect when you first see that duty no longer applies. And the government has issued guidance on vulnerable children and young people, which makes it clear that essentially what everyone needs to do during this period is be flexible. So the intention of this legislation is not to get people or get schools or local authorities off the hook in some way. It's about allowing local authorities to have flexibility for a short period of time to manage their resources in a most effective way. So in the guidance, it does, for example, say that special schools and residential schools should be a priority. The government wants these to stay open if possible. Staff might need to be redeployed to help support those particular schools. And they're sort of more of a priority than mainstream schools under the guidance, because it's recognised that children who attend those schools are likely to require enhanced support from their educational provider. The guidance also acknowledges that some children might need to attend an alternative setting for a short period of time. So if their particular special school has had to close for staffing reasons or whatever, it might be that they have to attend an alternative provision. But again, the intention is that this should be for a short period of time only. So essentially what this all means, I think, is a period of flexibility and adaptability, and hopefully for only a short period only. Although I realise that we just have no idea how long this will actually go on for. So that's an overview of what might change under the new legislation. I think it's important to recognise what should still be happening, what is unaffected, and what should still be going on. Well, there's actually quite a lot because, you know, we've set out in the previous slide for you, these are the things that the Secretary of State is allowed to change. There's obviously lots and lots of sections of the Children and Families Act that relates to EHC plans that the Secretary of State hasn't been given power to change within the Coronavirus Act. So, for example, local authorities should still be assessing children and young people who might need an EHC plan and carrying out EHC needs assessments. We recognise that the timescales for that might change if new regulations are issued, but certainly the criteria for accessing an EHC needs assessment or an EHC plan hasn't changed. So those assessments should still be ongoing. Now, obviously, again, we have to be flexible and adaptable in this period, and some of those assessment processes are likely to be impacted by things like schools being closed and by experts not being able to go out and directly assess people face-to-face. However, some of these assessments can happen by video link. For example, educational psychology could still happen by Skype call where possible. Recognise it's not ideal, but it is a way of trying to progress some of these assessments and not completely park them until this is over. There's also no reason why alternative schools can't still be investigated, even if they now have to be looked at remotely rather than visiting in person. Annual reviews, they should still be happening where possible. And again, it's in local authorities' interest where it's possible to have an annual review to do it, because otherwise, once this is all over, they're going to have an absolute heap of children who they haven't reviewed for a very long time. So where possible, these annual reviews would still be happening. And again, that could be by video call or by conference call where necessary rather than in person. And importantly, decisions can still be appealed. So that hasn't changed either. So the tribunal is still open and accepting appeals. And the thresholds and the reasons for appealing haven't been impacted by the Coronavirus Act. So just a reminder of the types of things that the tribunal can consider. It's a refusal to carry out an EHC needs assessment, a refusal to make an EHC plan, if you disagree with the contents of the EHC plan, or if the local authority refuses to make amendments following an annual review, or if the local authority refuses to carry out a reassessment or they cease to maintain an EHC plan. So all of those reasons still apply, and so challenges can still be issued at the tribunal. And just a reminder that legal aid is still available, and it's based on parents' finances, not the child where they are under 16. And legal aid covers the initial advice and getting expert evidence, doesn't cover representation at the hearing itself. And that time limit of 2 months still applies as well. So how has this all impacted the tribunal? Well, the tribunal is still trying to operate as normally as possible in this current time. So, as I said, those deadlines and timescales for appeal have not changed. All hearings are now taking place by telephone or by video link. And actually, the feedback from the tribunal that we've had so far is that this has been such an efficient way of dealing with everybody's hearings that they've actually got additional space for extra hearings, and they're able to kind of schedule in more urgent hearings if needed over the coming weeks. And for anyone who works in the tribunal, that's actually like music to our ears, because lots of the tribunal has been full up with hearings for a long time, with lots of hearings having to be adjourned because there hasn't been enough space for them. But actually, it turns out that one of the benefits of everything being done remotely is that they've got more space and they've got capacity to pick up urgent hearings. I mean, the tribunal has, of course, been impacted in terms of staff shortages. So, for example, there is reduced capacity in terms of admin support for the tribunal at the minute. But as I say, hearings at the minute seem to be operating as normal. Local authorities still have to prepare bundles. Again, there are going to be some practical issues with that, for example, sending out paper bundles. However, at the minute, the guidance from the tribunal is the local authorities should still do their best to find a way of sending paper copies of bundles to parents. I haven't put it on the slide, but of course, experts also need to give evidence by tribunal. And again, they're being able to do that by video link as well. So although we're not in ideal circumstances, the tribunal and the parties and experts and local authorities are doing their best to be as adaptable as possible in the current climate to try and ensure that parents still have access to appeal routes where they need them. Right, that was my whistle-stop tour through some of the changes. I'm going to hand over to James now, who's going to take us through the rest of the slides.
Hi, hopefully everyone can hear me. Yeah, sorry you can't see me today. You're not missing out much, so don't worry too much about that. So I'm going to look at first the practicalities of kind of school closures and what the guidance says around that, because there is guidance on that issue. Trying to change this page. Doesn't seem to be working. Is there there we go. So 1 second, I think we've gone a bit too far there. So I think the first thing to bear in mind is that the government hopes that most children can stay at home if that is safe to do so. But there are two main exceptions to that. Those being children of key workers. So probably by now we're all kind of slightly familiar with the definition of a key worker. So that kind of includes anybody really that works for an essential service. So NHS workers, the people who kind of take our bins, kind of all of these postal service, all of these people are key workers. So they are an exception. They're able to attend school, as are vulnerable children and young people. And the definition of a vulnerable child is set out in the guidance, which Caroline referred to earlier. Essentially, that will include anybody with an education, health and care plan. They're automatically a vulnerable child and they're therefore entitled to continue to attend school if they wish. There is potential for someone to still meet the definition of a vulnerable child, even if they don't have an education and healthcare plan. For example, if they have a social worker, but that won't be an automatic thing. Whereas with an education and healthcare plan, you're automatically classed as a vulnerable child. So those people are exceptions, and they should be able to attend school. Now, obviously, the government hopes that most children will be able to stay at home if possible, and if that's safe. But the schools should be there for anyone who needs it. And in terms of how that should happen and how that decision should be made, the guidance is kind of quite clear on this, that what should happen in relation to any vulnerable child or child of the key worker, for example, is that the school and local authorities will need to consider the needs of all children and young people with an EHC plan and complete a risk assessment for each. So an individual risk assessment for each child to consider things like the potential health risks to the child from COVID-19, bearing in mind, for example, any underlying health conditions. So that must be done on an individual basis, and potentially advice should be sought from health professionals about that if that's going to be needed. They should also be looking at the risk to the child if some or maybe all of the elements of their education, health and care plan can't be delivered, for example, at home or in school. And so that needs to be weighed up as well. Also, they need to consider as part of that assessment the individual parents' needs at home and whether or not they will actually be in a place to ensure the child's health and care needs can be met safely. So some children might have needs that kind of do require key workers to come into the home, for example, because maybe the support that they require could be beyond that, which a parent could be expected to provide. And also that risk assessment should consider the individual's well-being as well to potential changes of routine, for example. So all of that should be considered by the local authority and by the school. So they should decide between themselves, really, who's going to do that risk assessment and make a decision as to, whether or not the child should attend school, and if not, what should be put in place instead. So if you've not had that risk assessment, then that is something to kind of think about flagging up if you do have concerns about the current situation. So I'm just moving on to the next slide, hopefully. So as we kind of mentioned about the two categories of children with education and healthcare, so the guidance talks about there being two categories of children with education and healthcare plans. So this risk assessment has happened, and usually what will be the case is the children will fall into one of these two categories. So one category of child could be someone who would be at significant risk if their placement at school wasn't able to continue. So maybe some children where it's not going to be safe for them to be supported at home. So perhaps that could include children with profound and multiple learning difficulties, or children that receive and rely upon a significant level of personal care support. So in those situations, local authorities should support them to continue attending school and should support the school stay open where possible. Now, there might be situations where, for example, schools have to deploy staff from elsewhere, or you might see instances where kind of schools come together in effect to provide the support for the children that do still need to attend. So that's one category of child where that child will have to still attend school. The other category is that there will be some children whose needs can be met at home. So, for example, those that don't need a high level of personal care and have needs that can be met by their parents or carers at home. So those are the two categories, really. And usually kind of the risk assessment should help inform which one of those categories a person falls into. So that risk assessment's crucial, really, in making kind of good decisions about what should happen. I'm just moving on to the next slide, hopefully. Oh, it just seems a little bit slow. Bear with me. So the next thing I was going to talk about when the slide gets there is GCSEs. So here we go. Oh, we've gone too far. So obviously exams, people will be aware that exams have been cancelled this year in terms of GCSEs and A-levels. And instead, what is going to happen is that grades are going to be awarded by teachers. Now, how will that happen? Ofqual have issued some guidance to teachers about how to award these grades. And so do have a look at that if it's something that is going to potentially affect you. That confirms that those grades should be based on a variety of evidence. So mock grades are one indicator, but that shouldn't be the only thing. So also they'll need to take into account things like the quality of work done in class. And there's lots of factors that are set out there that should all be weighed up. Now, the guidance confirms that there, as with kind of exam results, there is a need to ensure consistency of marking across different institutions, because it may be that kind of, one person might kind of mark slightly differently to another, and there does need to be that kind of moderation of the results. So that will happen, and the guidance confirms that will happen, and we'll look forward to kind of seeing the details of that. Also, the guidance confirms that those marks, the marks that the school give, won't affect their performance rankings this year. So they're not going to impact on that, and so that shouldn't be a consideration, for example, when marks are being given. And the other thing to look out for is that there is going to be a consultation launching shortly on a suitable appeals procedure for people who maybe get a grade and disagree with that, and how they can appeal and be assessed again. So there will be an appeals procedure, and obviously if you are going to be impacted on that, then look out for the consultation, and you should be given an opportunity to feed in your views to that process. So that's in terms of education for children with special educational needs, and kind of hopefully now we've gone through the key changes, really, or in some ways lack of changes at the moment, but potential changes as and when the Secretary of State issues this notice. There will be, you may have seen that there have been some changes to the duties on social services by the Act. Now, the key point there in relation, because I imagine the majority of you dialing into this will be parents of children that are under 18. Now, in relation to that, the Coronavirus Act doesn't actually change any of the duties owed in terms of children's social care. So the duties there remain as they are to a large extent. So, for example, if you're receiving social care already, then the duty to provide that and to continue to meet your child's needs will continue, and yet the law is unchanged. Now, there may be some practical issues that arise due to shortage of staff, for example, but the legal duties are still there and there's still teeth to them. So, just bear that in mind, that it hasn't been watered down. Now, contrast that with the situation in terms of adult social care. So what the Act does, we're talking about anybody over the age of 18 or over. Now, what the Act does in relation to that is gives local authorities a power to issue what's called an easement. So where they basically declare that they're temporarily unable to meet the needs under the Care Act and explain why. So that really is talking about envisioning a situation whereby, because of staff shortages, for example, a local authority just has to manage its resources in a certain way. Now, in those situations, once that happens, the Act allows for many of the duties under adult social care, which are contained within the Care Act, to be temporarily downgraded to powers. So that means at the moment, for example, there's an absolute duty on a local authority to carry out a care assessment for someone that might be in need of care and support. There's an absolute duty, once they've carried out that assessment, to meet any needs that have been identified. If a local authority makes this decision, and this needs to come from the Director of Social Services, then those duties become watered down slightly, and it's more than a power that they have to exercise reasonably. So that will give local authorities some discretion to decide kind of where they allocate their resources, and that could, for example, cause someone to find it difficult to get an assessment of their needs, or it could in theory lead to support being reduced in certain circumstances. Now, one key potential change in relation to children, is whilst I said that the Act doesn't change any of the duties relating to children, where it does potentially have an impact is in relation to children that are turning 18, because the Care Act contains a duty on a local authority to complete what's called a transition assessment. So that should be an assessment kind of before the child turns 18, at a time when it's appropriate to look at, okay, this child's going to turn 18 shortly. What, at the moment, they may be receiving children's social care. What social care needs are they likely to have once they turn 18, and what support the adult services need to put in place to meet that. So, for example, do they need to live independently and move away from the home? So that assessment should be done at the moment before the child turns 18. And there's also provision in the Act that means at the moment, which means that what used to happen years ago, before the introduction of the Care Act, is we used to have problems whereby a child would turn 18, Children's Services would say we're no longer under any duties, and so that support would fall away. But adult services might not yet have actually picked up the baton and worked out what they were going to do. And so that created a bit of a cliff edge whereby children at 18 might lose some support for a period whilst they waited for adult social care to do their assessment and work out what they were going to do. What the Coronavirus Act does, if, again, this is all on the basis of if your particular local authority makes this decision to make this declaration, then that cliff edge would be reintroduced to some extent. So just be aware of that, really, particularly if you've got a child that maybe is going to turn 18 in the next few months. Just think about kind of have adult services done an assessment yet? If not, maybe start speaking to them to see where that's up to. But just bear in mind that the duties in relation to that may be slightly watered down if your particular local authority issues this type of declaration. So again, it's important to note that whilst it does change the duties somewhat in terms of adult social care, local authorities will still be expected to continue meeting needs as they are now, where possible, and all of the guidance around this issued by the government says that this is really kind of an exceptional thing to take into account staff shortages, and local authorities should be taking reasonable steps to meet needs where they can. So that's the situation in relation to social care. Just moving on to the next slide. So just to summarise, kind of we've gone through now all of the education kind of changes to SEN law in terms of school closures and social care. So in terms of the issues that we're seeing at the moment, over the past week in particular, I think now things have settled down and people are starting to get into a bit of a routine. We have started to get more calls from parents with issues such as children with education and healthcare plans being at home but not really being sent any work, or if they are sent work, it's often kind of work that's not being differentiated for their child's particular needs. We're seeing issues of annual reviews being indefinitely postponed, therapy in a plan not being provided. So maybe a child's EHCP requires an hour of speech and language therapy a week, and that may not be happening anymore, and delayed education and healthcare plan assessments. So I guess the key thing at the moment to bear in mind, like Caroline said, is at the moment, all of these duties in terms of special educational needs and education law haven't actually been changed by the Coronavirus Act as of yet. And so there's still, for example, a duty to provide suitable education for children out of school. There's still a duty to provide provision in accordance with an education and healthcare plan where possible. So if a child plan does set out speech therapy, for example, can that be provided? And I think Caroline touched upon that in one of her slides. So all of these types of things, if you are concerned about that, the legal duties do still exist, and there is scope to challenge those types of decisions by way of judicial review, if you are concerned ultimately. Now, obviously, judicial review is a last resort, and in the majority of cases, these types of issues can be resolved through correspondence with the local authority, because all of these duties ultimately fall on the local authority. So just bear that in mind. In terms of judicial review, obviously, hopefully you won't need to do that, but ultimately with the judicial review, the legal duties are owed to the child, and so it's the child's means that are assessed for legal aid purposes. So just bear in mind that legal aid is potentially available there. Also, I have seen some instances of some local authorities seeming to get ahead of themselves and kind of sending out correspondence that the law has already changed. So again, things like that isn't accurate at the moment. As we've said, the Secretary of State hasn't issued that notice, although we expect that they may do so shortly. So just keep an eye on that. I've been keeping an eye out, really hoping that no changes were announced during this seminar, and they don't seem to have been as of yet. So I'm just moving on to the next slide, hopefully, where we've got some questions that we can go through. So these are questions people sent in prior to the seminar. And so I'll just go through some of those, and then we'll come on to ones that have been asked during this event. So one question we had was, we support two families who've had a draft EHCP, and then they've had a final EHCP now. But because of the coronavirus issue, they're both self-isolating at the moment and they've not really had the time to deal with it? And will there be any reprieve in terms of the timescales for appealing the plan? So once a plan is issued, a parent will have 2 months to bring an appeal. Now, as we mentioned, the timescales at the moment, nothing's been changed, so that timescale will still stand. So I would say, if you can, try and get your appeal in within 2 months. The tribunal will consider applications for late appeals, but you'd have to have a good reason, and there's never any guarantee. So I wouldn't want to advise anyone to rely on that. What I would say is that there is something that you can do if you are in that situation whereby you think you might want to appeal, but you've just not got the time to put your mind to it, is once you get a right of appeal, you have 2 months from the date of the covering letter sent with the decision, so the covering letter sent with the EHCP. Within that time, you need to show that you've considered mediation by contacting a mediator. And once you contact the mediator will give you a certificate confirming that you've spoken to them and decided not to mediate, or if you mediate, confirming that you've mediated. Once you get that certificate, you'll then get an extra month to appeal. So one thing that you can do if you are worried about time is you've got 2 months from the date of your decision. You can hold off contacting the mediator until right before the end of that 2 months. As long as you make contact with the mediator just before the end of those 2 months, that will be fine. You'll then be able to speak to the mediator, and then once you get that certificate, that will give you an extra month to appeal. So that could buy you kind of mean that you have kind of an extra month, and maybe even longer than that if you do decide to try and mediate first. So that's the answer to that question. Another question that we had was a young person was seeking a placement at a residential college, but the local authority have now named a local college which they consider can meet needs. And there are concerns that wouldn't be suitable because the child is a particular risk of grooming, and what can be done to secure the placement at the residential college in the current climate. So this is the type of issue that isn't affected by the Act. The right of appeal will still exist. So presumably there's been a plan issued naming this local college that will have activated a right of appeal. And as Caroline mentioned, the tribunal is still operating, and they're actually kind of a bit better resource now because of the lack of face-to-face hearings. So yeah, that would be what you would need to do. The one consideration there would be to need to think about how to gather evidence in the situation, because often, for example, in these situations, parents will be looking to get independent evidence from experts, potentially to provide information about the child's needs. In that situation, those expert assessments can still potentially take place, but it probably won't be possible to have face-to-face contact in the current situation. But I know that experts are set up to work remotely and do assessments that way, and they can still review the papers and speak to the relevant schools and professionals. So there are still ways around that. So, but yeah, I think the answer there is to appeal as normal. Another question is, how can we work around the new bill in respect of completing education and healthcare plans in time for September for children starting school then? So again, the issue there is that the timescales for completing education and healthcare plan assessments and issuing plans haven't changed. So legally, those timescales do have to be adhered to. Obviously, there will be some practical difficulties, but as I mentioned when answering the last question, in terms of expert assessments, there are still ways that they can be undertaken remotely. Information should still be able to be obtained from schools. So I think it's just trying to be creative, really, in terms of how do you get the information that would usually be gathered. And it might be that information, that there are some restrictions on that information, and it might not be as high a quality as normal due to that lack of face-to-face contact. But I think I think that there are workarounds there. And the plan and the timescales are still there, although they may be changed in the future. Lots of parents we've also had a query that lots of parents are concerned about transition to new schools and getting new provision that's set out in an education and healthcare plan. Again, we understand those concerns. I guess one thing to bear in mind is at the moment the duty to provide the provision in the plan hasn't been changed. When it does change, as and when the Secretary of State issues a notice, the local authority would still have to exercise reasonable endeavours to provide that. And there is provision that could be provided even if a child's not able to attend school. There are ways potentially to deliver provision at home, so maybe by video, or if it's absolutely needed, there might be scope for somebody to come in with appropriate risk assessment and things like that. So there are potential solutions there. And as and when schools reopen, there'll need to be planning around kind of transition and maybe looking at staging a transition with a mix of home provision and kind of building up to attendance at school. Another question, a sixth former, will they be able to repeat year 13 if they're not happy with their assessed grades? Would that be their decision, the schools or the local authorities, and what are the financial implications of this? So currently that's not necessarily an option, although we mentioned that there will be an appeals process and that that's being consulted on at the moment. So that's one thing to bear in mind. The other thing I would say there is that there is always scope, and it would be at the school's discretion, and the local authority would need to have input in this as well. But there is scope for children with special educational needs being educated outside of their chronological year group, if the school agree. And I've seen many instances where that is something that's specified in a child's education and healthcare plan. So that could be one way around it, and maybe have those discussions with the college or school, and if there's a particular need for that on account of the young person's particular special educational needs, then yeah, there's no reason why that can't be something that's agreed to. Another person's asked is, can we still apply for education and healthcare plan needs assessments? Yes, the answer is that at the moment you can make a request and the timescales for dealing with that request remain as they are. If a child, another question is, if a child is with an EHCP isn't attending school, what are the expectations for school support at home? So again, in relation to that, I would say one starting point is the education and healthcare plan. So have a look through the provision section, and is there any provision there that could potentially be delivered at home or remotely? So things like having access to a class with peers with similar needs may not be possible at home, but having literacy tuition or speech therapy or occupational therapy, all of those things are things that could potentially be delivered remotely or on an individual basis. So there is a duty to provide what's in the plan, and also there's a duty generally on local authorities to provide suitable education for children out of school. And as things stand, that hasn't been modified. And even when it is modified, there'll still be this duty to kind of make reasonable endeavours. So yes, I think there are duties to ensure that some provision is provided. That provision needs to be suitable, and where possible, the provision in the plan should be delivered. Another question, is it possible to enforce the right of a child or young person with an education and healthcare plan to receive a suitable education under the present circumstances? Yes, we've just covered that. That duty still exists. And as and when it changes, they'll still have to exercise reasonable endeavours. Caroline, I've realised I've been talking for a while. Do you want to cover any of these next few questions?
I can do. I think this is our last slide. We've got a couple of other questions that have come in while we've been speaking. So I'll just go through these, and so I can try and answer some of these other ones that have come in. Just running through these final questions. So someone asked about speech and language therapists having been furloughed, and they found an alternative speech and language therapist. Could they instruct them in the meantime? So I think this is a really good example of using reasonable endeavours. If a local authority can't provide their normal speech and language therapist, but you have identified one, you could ask for a direct payment, and you could potentially fund that yourself through a direct payment, or you could propose that new SLT to the local authority who might be able to fund it directly. So yeah, that seems to us to be a good example of what a reasonable what reasonable endeavours are, using different efforts and flexible means to try and ensure that the provision is provided. Next question, and this is one of the other questions that we've had that's come in while we've been speaking as well, but about children who don't actually have an EHC plan yet and haven't yet been assessed. So technically speaking, children who don't have an EHC plan are not currently automatically viewed as vulnerable under that government guidance about vulnerable children and young people. And so that means that at the minute, they're not automatically in the category of people who the local authority will try and keep at school. However, different circumstances will apply. So there might be children that have very high levels of needs who are clearly going to get an EHC plan, but they just haven't yet got their EHC plan yet. Certainly, we would expect those kinds of situations to be judged on their merits. And so children who do have high levels of needs, the local authority should assess them, should risk assess their situation and deal with them on a kind of case-by-case basis. In terms of actually getting your EHC needs assessment and needs plan done, we've already covered that. So those EHC needs assessments can still happen. It's just that we're having to be flexible and inventive about the way that we get those assessments done and trying to get them all done in a reasonable timescale. Just running through a couple of the other questions that we've had that have come in. So a few questions came in yesterday from people who, after we'd drafted the slides, so we had a couple of extra people that came in, a couple of extra questions that came in, which I'll just quickly have a look at. So somebody said about being at home with several children who have additional needs and feeling a bit overwhelmed. I think that's the kind of case where the guidance says that local authorities should be risk assessing those children who have EHC plans and additional needs to see which ones they should try and support and keep in school. And even if your child might not automatically fit into the needs a really high level of support category, if you're going to be a parent at home on your own with 3 children with additional needs, that seems to me to be the sort of case where they probably should fit into that they should really be in school if possible category, and the local authority should therefore be trying to help keep them in school if possible, and that's what the guidance in the law currently says. So if you are in that position, you have concerns, I would speak to the local authority and say you think they should fit into the category of children who should still be receiving education in school, to try and help you out. That being said, we did have a question from someone who talked about the lack of PPE for schools. I think that's a whole extra issue in itself, which obviously we can't really cover in this session. I think PPE is obviously just a massive issue in the country at the minute, and I'm not aware of any specific guidance for schools on using PPE. Obviously, in an ideal world, they would have it. I think this comes down to the risk assessment of whether it's suitable for children to be in schools or not. So I know that there are lots of parents who have children with high levels of needs who are effectively choosing to keep them at home, even though they might be able to keep them in school if they really wanted, because they're balancing the risk to their health and would rather that they are shielded at home. This is, as I said, just a completely fluid situation, and I would hope that in a few weeks' time some of those PPE shortages might have been resolved, but and we might be sitting in a slightly different situation than we are now. But for now, I think that's a difficult one that we're trying to balance. Just look through some of these other questions that we've had, because some of them I think we've already answered. Yes, that's a really good point. There's someone who mentioned that their child doesn't have an EHC plan. I've already talked about those duties generally, but this person has reminded me that, yes, of course, the Equality Act does still apply, so reasonable adjustments can be made. So normally for children who don't have EHC plans, you can have a system of SEN support in school, and schools have to make reasonable adjustments. And those duties haven't been affected by the Coronavirus Act. So yes, technically schools are still required to meet the needs of children who have SEN. They should be making some reasonable adjustments in the way that they send provision home, for example, or if they're sort of providing tasks for people at home, there should be taking account of that. I think we have to acknowledge that schools and local authorities have been kind of thrown into this as much as everybody else. And I think the last couple of weeks have been an absolute whirlwind from all sides. Once the dust has settled, hopefully, I mean, this week starts to feel a little bit more like the dust is settling. I'm hoping that lots of local authorities and schools will get more into the swing of this. And stuff that hasn't yet been done, perhaps in making some reasonable adjustments, differentiating some work that's being sent home, will start to be done, because certainly those legal duties remain and are still there at present. Someone else has asked how we will know when the Secretary of State makes a change. Well, it's a good question. Me and James just check the Department of Education website every now and then, just to make sure that they haven't issued a notice yet. So it will be on the DFE website, and they will certainly tweet about it as well. And if anybody is on Twitter, I mean, there's lots of people like us and other barristers, campaigners, charities who will certainly be making it making it known and making it clear once that notice has been issued. But it should be coming out through the Department of Education's channels. Right, I think that's the majority of the topics that we've covered off. A couple of people have asked specifically about social care, but we've sort of discussed that in as broad terms as we can at the minute. So as you said already, with adult social care, the duties are going to be downgraded to powers once the local authority has decided that it doesn't have capacity to meet all the needs of people in their borough for that particular period of time. I think it should be said with those social care laws that the guidance on social care actually softens that down quite a lot. So whereas the Act, when we first saw the bill, we were sort of plainly horrified that all of these hard-won duties in the Care Act were going to be downgraded to powers, and what that might mean for people who have high levels of needs. The guidance softens it quite a bit and effectively says that local authorities should still be doing all they can to meet all of the needs anyway. And so what we certainly wouldn't want to see is local authorities, using this as a kind of blanket decision not to provide anything or not to carry out needs assessments. The guidance makes it clear that, you should be doing all you can to continue doing this. And the idea behind the law is to give those local authorities flexibility, not to get them off the hook completely. So I know it's an uncertain time, but I think we should still be working with local authorities, being flexible and understanding the pressures that they are under, but also finding inventive ways, more flexible ways, giving them more time to get something done, but still trying to get these things done to ensure that everybody's needs are met. Right, just do a final run through, just make sure there's nothing else that we haven't covered in some way. Yeah, I think we've pretty much covered everything. If there's any burning questions that you feel that we haven't answered or you have a concern about, I think we've got, James, can you go on to the next slide? I think there's a slide at the end, if you can get onto it. Oh, don't worry about it. I think, is there one after that, James?
Let's see.
Yeah, I think our events team have said if you want to send any additional questions that you have that you feel like we haven't answered to this email address, they will try and make sure that things get filtered through to me and James, and we will try and come back and answer them for you. James, if you just go back 2 slides again. Sorry.
Problem. I will do my best.
To the one with the pink.
Yeah. It seems to be a bit of a lag.
I hope that we've done. We've helped today in trying to explain what some of these changes are, but also to try and reassure how we can try and find a way through the situation. Be flexible, still ensure that people's needs are met, try and find inventive ways of ensuring that, we don't end up in a situation where people are falling through horrible gaps and not getting the provision they need. We obviously recognise that we are in a slightly, and I hate to use the word, but an unprecedented situation, and things are quite quick moving, but we will certainly be doing all we can to support people through this time. If you could just go back one, James. Trying. Oh, there you go. So just to make you all aware as a final point, so at the firm, we're doing our best to try and ensure that everyone has got access to up-to-date information on the coronavirus act and what it means and the impact of coronavirus on various areas of our life. And so hopefully if James gets the slide up, I can show you that we, if you need advice on anything, obviously special educational needs, but social care, also anything relating to your sort of personal life, if you're moving house, if you've got a business which is impacted by coronavirus or employment laws, we're trying to provide really regular updates on our coronavirus page. So please feel free to access our website, and we've got lots of blogs and webinars going on all the time in relation to lots of different areas of law. So hopefully that will help you all out as well. Apart from that, we finished bang on time. So I'd just like to thank you all very much for joining us today. Hopefully it's been helpful, and I hope to see you in person and not just virtually at some point in the future. Thank you very much. Bye.
See you, everyone.